When trials vanish and cases settle, when consent-based dispositions and litigation are the main legal activities, how can we expect new norms to emerge, a new public sphere to develop? Doing a research study on the changing role of the judiciary in an age of vanishing trials, we came up with a few ideas about new public legal horizons for judges, lawyers, and mediators, for litigants. For judges, expanding judicial settlement discretion. In an era of vanishing trials, there can be still a meaningful judicial conflict resolution role that benefits litigants and society at large. We suggest a transition to a conscious judging that expresses a multi-level approach to access to justice, incorporates new values of the legal system other than the need for efficiency, and acknowledges awareness of the complexities of contemporary law. We construct a new terrain for judicial discretion, which integrates a broad and pluralist perspective on what law and conflict resolution are, including critical perspectives. In addition, we suggest training to help judges conduct broad settlement encouraging practices. We insert principles of conflict resolution into the judicial work of pursuing settlement. For mediators and lawyers, more public aspects of mediation emerge in an era of vanishing trials. Mediation is becoming a new, sophisticated form of law in cases that are polycentric and too complicated to deal with effectively in trial. A new model, which we name authority-based mediation, is described by us as expressing new public roles for mediators. Within these new forms of mediation, norms are generated through mediation agreements and sometimes during settlements of Supreme Court cases. Sophisticated settlements in courts may generate public norms while emphasizing the importance of compromise and dialogue. This new market of norms may be framed and published as a new form of precedent. For litigants and laypersons, we see the litigant before the law and the common people as entitled to more responsive legal systems. Such systems should, first, publicly emphasize the role of law in helping people to prevent conflicts and resolve them. 2, encourage informed decision-making based on available and relevant data on settlements. 3, coach litigants in conflict resolution and encourage innovative thinking on creative solutions. 4, strengthen relationship community work in solidarity. Instead of emphasizing efficiency and speed where litigants drift towards settlement without proper information, a coherent dispute system design which highlights shared interest and relationship may increase trust in the judiciary and contribute to a more public health-oriented jurisprudence of prevention, improving the well-being of citizens with conflicts. What happened to us while we were searching for fast and effective legal justice is that the core notion of adjudication as a structured process to decide cases after the presentation of facts and norms has collapsed. Adjudication as we know it, as a basic tenet and claim of law for formality, has vanished in many legal systems. Now is the time to reconstruct new public horizons for law and conflict resolution, which can be the next adventure within the life of the law. Horizons of conflict resolution provide a new imaginary for the law to live through.